there's a crew in town. The head hillbillies are making their rounds. Small town whispers loud and clear. The sheriff shot the judge in his chambers chair.
Sheriff got a secret he won't keep. Judge shot dead in his disbelief. A lot of people have some stories to tell. Dark pass away, get the sound of a shotgun shell.
All the secrets spill on down. Voices loud in this old town. From the courthouse to the ground, rumors fly and they can't be bound.
Neighbors hide behind their blinds, whisper tales of troubled minds. Skeletons covering the mountainside, a treacherous reality in the pines.
Winter reveals the hidden lies. Moonlight couldn't mask the cries. Shadows caught in sunlit skies. There's no cover, no disguise. All the secrets spill on down. Voices loud in this old town. From the courthouse to the ground, rumors fly and they can't be
Winter reveals the hidden lie. Moonlight could mask their cries. Shadows caught in sunlit skies. There's no cover, no disguise.
all the secrets spill on down. Voices loud in this old town. From the courthouse to the ground, rumors fly and they can't be bound.
Hello, everybody. How are you? How are you? Welcome to the show. If you've not been here before, welcome to Hillbilly Crime. My name's Elizabeth, and Sweet Tater she might be with us. She was running home to jump on, so as soon as she gets here, she'll be joining us. So today is the big day. Today is the hearing for Sean Mickey Stines on September 19th. Let me go over here and see if what they wrote in their description. So we're going to jump on Law and Crime, their live stream. There are a couple news people that are streaming today. Law and Crime is one, and Court TV is another. So they've got the live streams going, and they're nice enough to let us piggyback off of them. And so we're going to be watching it here on our show too. Thank you for joining us. How is everybody today? Excited for this hearing? Everybody's waiting to see what happens. So the things that they're going to be talking about is one of the sides had requested a dismissal. I guess it was the defense, of course. They requested a dismissal, I think, which, of course, that's not going to be granted, I don't think, which I'm no lawyer. Remember, I'm not trained as a lawyer at all. I just have a master's degree in what my actual degree is in. My bachelor's is in criminal justice as a whole. And my master's is in juvenile justice policy and leadership. So it was one class away from a master's in corrections, which is ironic. So anyway, that's where my level of education and knowledge comes in, to kind of try and explain how our justice system works to those of us who don't know. You know, a lot of people are just ignorant to what really goes on in our courthouses and our courtrooms, unless you have had a personal experience with law enforcement, you know, and most of us have, especially us hillbillies. Especially us hillbillies. Okay, yes, let's do a poll. Thank you, thank you. Now, put a 1 in the chat if you think that he's going to get bond. Put a 2 in the chat if you think he won't get a bond set. So put a 1 in the chat if you think he's going to get a bond set, no matter what it will be. And put a 2 in the chat if you think he won't. Oh, wow, man, look at that. Hang on a second here. I gotta take me a blood pressure pill. My face is as red as a beet. I can feel my blood pressure up too. Man, I don't like having high blood pressure. It only goes up. I only have problems with it when I get fat. Which I'm not too heavy right now, so I ain't worried about that. But I do worry about my blood pressure. All right, so what do we got? 1, 2, 2. 1, 2. I sure hope it doesn't freeze up on us a lot today, y'all. I'm sorry. The only other way that we can do it is if we just do it straight without the software. But when we do that, we can't put no comments up on the screen. There's a lot of things that we can't do when we just do straight YouTube. So I guess it'll be all right. Hopefully it won't do it much though. But so while we are waiting on this hearing, let me look and see what I had. Oh, okay. I know what I wanted to do. Thank you. All right. Let me get this up here. So those of you who, you know what happens when life just one day you're driving down the road and your car quits or something, you know, and what do? Well, you end up having, if you're like me, you end up having to go buy a new car. Like, I've never had a brand new car. I've never had a new vehicle. I always just bought a used one for a few $1,000s, whatever I could afford, or my mom could afford to help me with, right? And so I had this little purple car that used to be hers. She gave it to me, and I drove it for probably about 12 years, 13 years. It was a little matchbox car, a little purple matchbox car. I loved it. It was so good on gas and everything. And I hit a dog. A great big dog ran out in front of me one day, and we were coming back from football practice. And it killed the dog, and it destroyed my car. My car wouldn't never run again. And so I ended up having to go buy a vehicle. And I want to tell y'all about Payne Gap Auto Sales. This little old boy put this car lot in up the road in Payne Gap. And he's been there for a few years now. And he's a really nice boy. And he's helped a whole lot of people out in this community get good cars, especially as women. If you're a single mom like me and you don't know anything about vehicles, there you go. There you go. Go to Payne Gap Auto Sales and they will hook you up. All right, so let's get into the trial. Or, well, it's no trial, but it'll be starting any minute. They said that the news is crazy down in Whitesburg. They say it is everywhere. The news, all kinds of them. I don't know who all's down there. They said that Fox News is down there. All kinds of them. Oh, there's Mommy. Hey there, Mommy. How you doing, sweet tater?
Well, I'm home. I did my radio show. I didn't go down and look at the courthouse. I didn't even think about it.
Yeah. It was busy. I reckon there are so many people down there that it's a big contrast compared to when all this first happened. Me and one of my girlfriends went down there that night, and it was a ghost town. There wasn't nobody down there. And everybody was just being so mean and rude. And I mean, I know we've just had this great big disastrous thing happen in our town, but the way that it was like, there were several people there right when it happened, and they were standing across the street from the courthouse, and they pulled out their phone and they started to record. I mean, this is a huge event that just took place. You would want to document it. It's not just, oh, they're just being nosy. I mean, you want to document this moment. Well, that's really going to suck if that happens a lot. All right. Sweet tater. Oh, yeah, if it freezes, y'all, just bear with us, I'm sorry. I don't know what to do. I've restarted everything, restarted my internet, I've restarted my computer. It's not me. It's not anything that's got anything to do with anything I can control. So it's just frustrating. But y'all, listen, we're blessed. We are blessed. We are not stressed today. Not stressing. My blood pressure just can't take it. Yeah, I don't know. It'll be all right though. I even decreased the resolution from whatever it was down. We'll be all right. I was talking about how we get information has changed over time, and people get territorial. Like the only people that are allowed to talk about any of this are reporters in their newspaper, or if you call in and do a comment in their speak your piece, only they can print any kind of anonymous comments. They're the only ones that are allowed to do that. So, even though it doesn't matter, we're not allowed to do it. We're not allowed. Nobody can do it except for them. They're the only ones that are allowed to talk about it. Those people down at the courthouse, they're the only ones that are allowed to talk about courthouse business. That's the people's house. That's the people's house. That's what it's supposed to be anyway. You got to remember they're elected to represent the people, but it ends up kind of being skewed to be like, well, who's going to win that golden ticket? It's like a golden ticket to the rich house, right? If you get elected into a political position in Letcher County, it's a golden ticket. And then it's up to you how you use that golden ticket, right? Yeah. You have to either go along to there we go. Mama, usually whenever I freeze up, it keeps Mama on here. you know. Sorry, y'all. It is what it is. We're trying. We are trying. See, I think somebody said Court TV was already on. Let me go see if I can find it here. No, there. Yeah, there it is. Yep. Oh, wow. Here, y'all. I gotta go back and see what's going on here. That's Kevin's sister. I think that's Judge Mullins' sister, if I'm not wrong. That's Mickey's wife in the black. I don't think Mickey's in there yet. So they just came out of the judge's chambers. That's where they go back there and discuss, what they need to talk about without us knowing. There's like a meeting room back there. You see, this is Jimmy Kraft's courtroom.
Who's
This
the
is where
young
Daniel,
boy?
that's Mickey's attorney, Jeremy Bartley.
Okay.
And then that is Jackie Steele, prosecutor. I know my blood pressure's up so high. A meat room, yeah.
Yeah, he sort of looked like my neighbor.
Uh-oh, they said there's a motion made to move him back to Letcher County Jail, and he is trying to come back to Letcher. There is a motion made to have Stines moved to Letcher. I think they just put an order in for him to be transferred here. I haven't heard that yet. So we'll just have to. Yeah, I know I'm behind a little bit, but I put it back so we could watch it all. Thank you for being here. Yeah, I know I'm a little behind. I wanted to watch all of it. We didn't know that Court TV had it on. Long Crime didn't have it on yet. Sorry, y'all. But there ain't nothing I can do, so I can't get upset. We're just gonna have to freeze it. Oh, he looks awful. I pause it because I can tell when it freezes, so I pause it. And then whenever it unfreezes, I unpause it. So don't worry, we won't miss nothing. He looks. I think he looks bad. Bless him, Jesus. Bless him, Lord. Bless him, Lord. Bless him, Lord. I'm about to cry. I didn't expect him to look that bad. But Jeremy Bartley looks awful encouraging. Yeah, pray for him. That's all we can do is pray for him. I pray for them all. All he does is lay. I can tell you. He's got bedhead. That's all you have to do in these jails. They don't have no rec. You don't have that kind of stuff.
All right. Second circuit court will now come to session. Honorable Christopher Goins presiding. Please be seated and let the court come to order.
We are on the record. This is 24 CL 204. I'm a Kentucky versus Shelby Stines. My name is Christopher. I'm the special judge appointed in this matter. I will identify themselves and everybody counsel, please.
Jackie still got call the
Ramsey Down on behalf of the common count. Governor Carrie Bartley on behalf of Sean Fong.
Deputy Your Honor, Jeremy Bartley on behalf of the District Mickey Stines.
All right, thank you. I see Mr. Stines is present. The court set this matter today for the status hearing to address a few matters. We'll be in such a position now where we will be able to set some upcoming court dates to get this matter proceeding forward. We have been waiting on a KCPC evaluation to be done on the defendant. That has been completed. It is currently under seal as procedure is done standard in any type of case such as this. That matter right now is under seal. There's been a motion for the KCPC evaluation to be unsealed. Mr. Bartley, that's the main purpose for that, as you wish to, if the court does set an evidentiary hearing on other two motions, you wish to have that as potentially more.
That's correct, Your Honor. Our intention is to have it for the purpose of those evidentiary hearings. I believe that it contains, without speaking about what it contains specifically, Judge, I believe that it does contain valuable information that the court would be able to use, particularly in the bond hearing in terms of coming to, making the court's findings that are necessary to determine whether Mr. Stines is a good candidate for a bond in this case. And so I think as it pertains to the motion to dismiss, Judge, there's also some information in there that will go directly to some of the testimony that was given at grand jury.
All right. And Mr. Steele, how long, you don't have a problem with response to that, in regards to that, how long do you want
Judge, if you give us 10 days, I think we got it last week, so if you give us 10 days to respond to that motion. Thank you.
All right. What I would like to do though is at least see how far we can get without addressing the pending KCPC evaluation issue. And the fact, so the court has read that, so it keep that in mind. But we can address first the motion to dismiss the indictment.
Your Honor, I will. Jeremy Bartley on behalf of the District, Your Honor. Your Honor, we filed a motion to dismiss on two grounds. Number one, under RCR 5.16, failure to provide or to have a transcript of the grand jury proceedings. Court knows RCR 5.16 requires that the testimony taken in front of the grand jury must in fact be recorded. Now, we kind of came upon that surreptitiously. We were listening to the grand jury tape, and there was a reference. Your Honor, I don't know if the court has made that grand jury. Can I speak to the content of the grand jury and decide for what I think?
Yeah, and for purpose of record, the court has provided a transcript, a CD recording of that we use for.
Thank you, Your Honor. So there's a reference to one of the grand jurors that said in our last meeting or in our previous meeting, and I'm paraphrasing it.
No.
And And so at that point, we weren't aware of the previous grand jury hearing. And so I inquired on that. They did respond to me. The response was basically, well, we met with them. The purpose was just to get a subpoena for medical records. And the judge, I anticipated that was a response. But I guess, one, what's odd about that to me is that I've done thousands of grand jury hearings, and if you want evidence brought to a grand jury, you usually submit it back to the hearing. I mean, there's no reason you don't have permission from the grand jury to subpoena. You send a subpoena, and you subpoena the custodian to the hearing. And then the second piece of that that concerns me is that even if we presume that is what was going on, and I don't know, there's no reporting, but if we presume that's what's going on, unless there was some sort of, telepathic thing going on, there had to be statements made to the grand jury that said, hey, this is this case, this is what we know, and I think the public was making the distinction that, well, if you don't come in to raise your right hand and swear, it's not testimony. Well, actually, the distinction is sworn testimony and unsworn testimony. I'd submit to you that the only way that you're asking for a subpoena and you're basing that on some sort of probable cause or evidentiary standard that you want the grand jury to consider, which is the only thing that makes sense. You have to tell them something. They didn't walk into the grand jury room and say, just look at each other, and the grand jury says, hey, we'd like a correct subpoena. Now, I will say this, I do agree with Commonwealth their legal advice to the grand jury, and the grand jury deliberations do not have to be transcribed. But whatever was said to the grand jury, they keep them to ask for or form their basis for asking for medical records, Judge. I think that should have been recorded, so we would have that available. And I think 526 requires it, and the remedy is that component shall form a motion to dismiss. I can address the other area, Judge. Okay. And the second area, Judge, I really think, Kendra, I don't. That may need an evidentiary hearing. It may not. I mean, I'm not sure. Well, I'll leave that to the Commonwealth as to the response to that. But in terms of the other portion,
You're talking about the statements made during the
yes, sir. As to the second portion of my motion, it's based upon Commonwealth feedback here, and Mr. Cox actually handled Mr. Baker in that case. We all know it in the prosecutor's community is the aluminum bat case. Detective goes in and testifies and says, basically if there was an aluminum bat used, this woman used an aluminum bat. In reality, it was a wooden stick or something like that. And in that case, the following conviction and appeal based upon that testimony being misleading, the Supreme Court sent back and said, look, if you give evidence to a grand jury, you get misleading. And this, the bigger debate really seems to be after that is that this arises from prosecutorial misconduct, which should stand with prejudice, or is it not? And to me, that falls into the without you representing the grand jury. And so when I look at the grand jury transcript, Judge, again, without getting into the KCPC report, one of the
All right. They said Law and Crime had a really good stream. So let's go over to them. But we're not going to jump ahead. Okay. Let me go here.
and
or as In the Jackson case,
And basing that on some specific, that should have been recorded, so we would have that available. And, you know, and I think 5.6 requires it, and the remedy is that you shall form a motion to dismiss. I can address the other area, Judge, or, okay. And the second area, Judge, I don't really think Kendra, I don't, that may need an evidentiary hearing, it may not, I mean, I'm not sure. Well, I'll leave that to the Coleman office to get the response to that, but in terms of the other portion.
You're talking about the statement that's made during the
Bishop. As to the second portion of my motion, it's based upon conduct behavior, and Mr. Cox actually handled Mr. Baker in that case. We all know it, and the prosecutor's community is the aluminum bat case. The detective goes in and testifies and says, you know, basically if there was an aluminum bat used, this woman used an aluminum bat. In reality, it was a wooden stick or something. And in that case, we would following conviction and appeal based upon that testimony being misleading, the Supreme Court sent it back and said, look, if you give evidence to a grand jury, you get misleading. And this, and you know, the bigger debate really seems to be after that, is it rise to prosecutorial misconduct, which should stand with prejudice, or is it not? And to me, that falls into the without you representing the grand jury. And so when I look at the grand jury transcript, Judge, again, without getting into the case of Houston report, one of the really things that bothered, one of the big things that bothered me was the grand
This
jury.
is live. We're a little bit behind, but it's going on right now.
Concerning mental health issues. And the last question before the grand jury retires from deliberation was, so he was in the same mind as far as the investigation was young, and the answer is yes.
I plead the blood of Jesus over us. All right, there we go.
Appropriate thing for Mr. Stanford, Detective Stanford, to opinion on, but the rules of evidence, I get it. I mean, if there's an evidentiary issue, that's not what we're talking about. But here's the thing. If you're going to let a detective testify about sanity and render an opinion, that grand jury takes that to heart. He's seen all these facts, and I submit to you, without getting, I can't reference the report, but I'll say this. You're hard pressed to find much in the way of the investigation that would support the adverse. And so this is what I believe. I believe that had they not been told by, it's very real. And you know, I can think of one witness, an attorney, who specifically said, I think he's had a psychotic break. And so to say that your investigation so far is showing us in the same mind, yes, I think there's at least enough there, Judge, for let me put the witness up there and ask him. Yeah. And then, Your Honor, there are additional items that I think are also of concern. There's a question.
You've cited those in your video.
I cited those, Judge, and those are additional items. And if the court doesn't want me going about each instance, I'll just say that is the sort of thing that I think we need to know from Detective Stamper. If you knew these things, why did you answer this misleading way? And I think it's reckless at best. And I don't know. We need a hearing to find out, Judge, what I'm asking.
Unless the court wants to certainly take it under submission and dismiss without an evidentiary hearing, we would request that as well, Judge, but if not, then we'd ask to be able to put on.
Sure.
Thanks, sir.
Ms. Dahl.
Thank you, Your Honor. Your Honor, the Commonwealth is of the position that we certainly acted in compliance with the rules of criminal procedure here, the rules specifically that were cited by defense counsel. And we would ask that the court to dismiss the motion, to deny the motion to dismiss the indictment as it's wholly without merit. Your Honor, here, counsel is correct in citing Rule 5.06 that we could have unilaterally issued a grand jury subpoena to obtain these mental health records. That is the power that the Commonwealth does have. However, in taking an extra step in the interest of transparency, as the grand jury is an independent investigative body, and to ensure that there was no argument that we were usurping our grand jury subpoena power, we appeared before the grand jury on October 17th of 2024 without a witness, specifically to ask for these mental health records from two different providers for the defendant. We appeared at that time. There was no witness. There was no testimony presented. Counsel, again, is correct that pursuant to Rule 5.16, had testimony been presented at that time, it should have been recorded and would have been required to be recorded.
Who appeared from the Commonwealth when that request was made?
Myself and Mr. Steele.
Okay.
Only the special prosecutors were present. No witnesses appeared on behalf of the Commonwealth.
Right.
And so, Your Honor, the rule is clear. It requires testimony in order for there to be a requirement for recording. And there was no testimony presented this time. And I think that is apparent. The court now has a copy of the actual recording of the grand jury proceeding for the testimony that was presented on November 21st, the only time that testimony was presented. And I believe a review of that testimony, some of which is referenced in the Commonwealth response that has been filed, will show, based upon the questions that were lodged by the grand jurors, the only thing that was requested at that time were this grand jury subpoenas for those medical records. I think that's reflected in the context of the recording of the grand jury presentation.
And as an officer of the court, are you representing that that was the only request made?
I'm sorry, Your Honor.
Are you, as an officer of the court, representing that was the only request made?
Yes,
There
Your Honor.
was no peripheral commentary or anything of that?
No, Your Honor.
Just,
Specifically request for those grand jury records, for the mental health records pertaining to the defendant, one from ARH and one for Leslie County Detention Center.
Mr. Steele, you
Just a point of clarification, if I understand your question, the went in and we said, we're the special prosecutors in this case. We're here just so we can get a grand jury subpoena for mental health records. They began asking questions, of which we did not have an answer to.
Right.
We never answered any substantive questions other than that. That's something we're looking at. That's part of the investigation. Those matters will be presented to you later. There was never, of course, at this point, the preliminary hearing had already been had. The video
go ahead, Mr.
And Your Honor, additionally, we asked the grand jury to memorialize what was being requested and as far as the grand jury subpoenas in writing, which was authored by one of the members of the grand jury and signed off on by the foreperson. The verbiage of that is reflected in the response as well, but specifically which records they were requesting and authorizing via grand jury subpoena. So those grand jury subpoenas were issued. The records were received. Those records were then promptly provided to counsel for the defendant on December 4th of 2024 in the very first discovery period. So in compliance with our discovery obligations, Your Honor. So the Commonwealth believes it's clear based upon the rules of criminal procedure that we acted in compliance with those rules. We have additional arguments as far as In the Jackson case, however, the Commonwealth does not feel it's necessary to delve into those at this time unless the court would like to hear them as they're reflected in the.
I've read your motion, or I've read your response.
All right, thank you, Your Honor. So clearly, we do not believe any evidentiary hearing is required with respect to the argument that there was no recording made. That is apparent from the recording that the court already has. So no evidentiary hearing is required. As far as the second argument, turning to the actual content of what transpired and what Detective Stamper testified to and the questions that were asked during his testimony to the grand jury in November. Your Honor, I think defense counsel is conflating the role of a grand jury proceeding with the role of a criminal trial. It is very clear under the law that they are distinctly different proceedings. The grand jury is an investigative body. The Commonwealth has no obligation, as reflected in an abundance of case law, to come in, to present exculpatory evidence, and to attempt to mount a defense for the defendant. That is not the Commonwealth's obligation. Additionally, the rules of evidence, particularly Rule 1101, does not says that the rules of evidence do not apply to grand jury proceedings. So hearsay, opinion testimony, the right to remain silent, all of those things are not required to be adhered to at a grand jury proceedings. If they were, our grand jury proceedings would be the same length as a criminal trial. It's not tenable.
The reason a grand jury proceeding for 30 minutes is the same as a 3-week trial.
Exactly, Your Honor. And so I believe counsel's arguments are confusing the two, the purposes of the two. You know, hearsay is presented routinely at grand jury. Opinion testimony, such as Detective Stamper's testimony, is presented routinely at grand jury. These are commonplace and they are permitted under the law.
You would agree, though, you can't be intentionally misleading.
Absolutely, Your Honor. Certainly. And Your Honor, the Commonwealth is of the position that an evidentiary hearing is not required. Everything that transpired when testimony was presented to the grand jury in November is captured on that grand jury recording. The Commonwealth cannot conceive of a reason to haul witnesses in to talk about what transpired because it's on that recording. And so we do not believe that an evidentiary hearing is reported or is required. Sorry, Your Honor. So, Your Honor, again, the court has that grand jury recording. We would ask that it be filed under seal as it was a grand jury proceeding. And we would ask the court to deny the defendant's motion to dismiss the indictment in its entirety without any necessity of an evidentiary hearing. And we would rely on our pleadings submitted for, Your Honor.
Thank you.
Your Honor, may I just briefly reply, Your Honor?
Yes.
Yeah, Judge, so I mean, I haven't confirmed anything. I said from the beginning, Judge, I understand, we're talking about the rules of evidence. The reason I cited to the issues where there were things that normally wouldn't come in is because there were instances throughout the grand jury when the witness was about to answer something the grand jury asked for and it was shut down. I was contrasting.
That's not unusual, Mr. Potter.
Oh, I get that, Judge, but my point is this: if you put that into context with what they let testify, then I think ultimately, Judge, if we put on that evidence, it'll show you that this grand jury was misled. I mean, the statement, to be honest with you, the statement alone, rendering an opinion on saying it is completely, in terms of, I get you don't have to be an expert, Judge, but if you say it, you can't mislead. And then, so I'm not asking the court to look at whether things should have been admissible or not. That I'm not at all. My point is that the grand jury is an investigative body, and they don't get to dictate what they hear if the grand jury is asking for additional stuff. So in other words, if they ask a question and it's germane, I'm not talking about relevance, but if it's germane, it's their grand jury. It's not common jury's grand jury. They're the investigative body. And so the reason I cited to the things that I thought should have came in is that it contrasts with other things that I think they asked and never got told because the questions were reformed. And that's why we're asking for the.
Well, thankfully, I've been part of about 20,000 cases being presented to a grand jury. I'm going to listen to the recording, and I'll be happy to review that.
And Your Honor, if the Commonwealth
Please,
may,
sure.
thank you. I would like to make a distinction. The Baker case, we're talking about misleading to the extent of an aluminum bat
Understood.
versus a wooden stack
Sure.
stick. I don't think there's nothing even alleged in the pleadings, even if you take everything in the pleadings that's been said today by the defense as true, that would be tantamount or even close to that, Your Honor. You know, as far as the mental state of the defendant at the time of the offense, that wasn't even an issue at the juncture of grand jury. That hasn't been raised since by defense counsel. So, Your Honor, again, I don't believe that those arguments are well taken. We would ask that you deny their motion to dismiss in its entirety.
Understood. All right, and I will get an order out on that. One, if I need to hold an evidentiary hearing in it, if not, I'll rule on it appropriately. I am going to take a copy of it with me to review for purposes of reviewing the pleadings.
Yes, sure.
All right, next in regards to the bond hearing.
Yes, Your Honor.
Baldwin.
Again, Carrie Bartley for Sean Stines, Judge. And we filed our motion for the court to, and it's been back quite a ways now that we
Sure.
filed that, but we did ask the court to kind of hold
Which is
on.
not abnormal. I know we've had some procedural things and evaluations, so
Absolutely.
that
And
is
that's-
something that had to be done.
We asked the
first.
court to hold off on setting it for an
Absolutely.
evidentiary hearing until after we received that report back. Judge, you know, I think by pursuant to criminal rule 440, I believe it is, we're entitled to an evidentiary hearing. I think it's going to be necessary for us to bring witnesses. We had some witnesses lined up. And I think it'll be necessary for the court to hear that evidence and make its findings on whether there are several factors by statute that the court has to consider when determining whether bond is appropriate. And there's an added level here, and I anticipate the Commonwealth will argue that Mr. Stines is not entitled to bond because of the way that this case is charged. Okay, so in that situation, Judge, they're going to have to put on proof. It's actually their burden to show the court if that is in fact what they argue, and I don't know, I'm just anticipating, but it is their burden if they're trying to preclude him from bond at all to put on proof that guilt is evident or the proof is essentially, you know, there's great evidence of the proof, right? And so I can anticipate what those arguments are going to be. I can anticipate all of that, Judge. But I think, given what we know, and again, without putting any of that on the record today, given what we know now, I think we'll have a kind of an argument on bond.
What would be your proposed bond, in light of the
Yes.
circumstances?
Absolutely. And given what his income is, given what he's able to post, and I think that's what the statute requires the court to look at is what he could reasonably post. We would
Public
propose.
safety is a factor also.
Absolutely. There are several factors, Judge. I just think that in terms of what the amount would be, the court has to look at what he could reasonably post if he is in fact entitled to a bond. So our proposal, Judge, would be 50,000 cash for property with any non-financial conditions that the court would require of him. The court could set a host of non-financial conditions, Judge, as you well know. However, I think that given Mr. Stines, and again, without waiving any of our,
Absolutely.
you know, any of our ability to put on proof, I would ask the court to take a look at the fact that he is, you know, the lowest possible risk level that one human can be in terms
I'm
of his
gonna stop you
pretrial
for a second.
service.
Pretrial risk assessment, with all candor to all parties,
Sure.
is something that, as a prosecutor, now as a judge, I don't have the utmost faith in.
I understand, Your Honor, but it is also something that the statutes require the
Understood.
court to take a look at. And there has to be some other evidence that the Commonwealth can put on, or some other evidence in front of the court that he would be a flight risk, that he would not return to court, that he would be a danger to himself and the community. And again, I think that's why it's important for us to be able to put on proof and to be able to put on some of the stuff that's in that basic piece of report. I think that when we are able to show the court what's in there versus, you know, all the other things, I just don't think there's anything to show that he's a flight risk. There's nothing to convince the court that he would be a danger to himself or others. And I understand why we're here, Judge, and I get that. But the courts have said consistently, and it's, I believe, the Abraham case, that you have to look at something other than the charge.
I
It has to be
understand,
something else, right? We can't just look at the charge to him.
that can be factored in.
Absolutely. So, Judge, I think we're going to need that testimony and we're going to need that report. I would ask the court, again, without waiving anything, I would ask the court to consider setting a bond. The court, of course, can do that at any time. And that would be our requested bond, 50,000 cash or property. If the court wants to hear just a little bit about what we would put on, again, Mr. Stines is a member of this community for his entire life, born and raised here. He has a great deal of family support through all of this, as the court can see. He has a wife and daughter that he can still go home to today. He was a member of law enforcement for basically his entire adult life, up until the point of his arrest. Is a respected member of law enforcement, a respected member of the community, and frankly, Judge, everything we've learned about him since then corroborates that. And I would have testimony to that. There's no evidence that he would be a flight risk. Nothing. He has no failure to appear on his record. He has no, property in the Bahamas that he can run off to. There's nothing. This is a man with a great respect for the law, and he's built his life around upholding the law and serving his community. Just there's nothing that I've seen that anyone's seen. And frankly, what we put on our proof of the court will see, there's nothing to say that he would not return to court. There's nothing to say that he would commit another offense. There's nothing to say that everything in this pretrial services report, respectfully to the court, is not correct. That he's a low 0-0 risk, Judge, because this is a man who, again, there's, with all due respect to the court and to everything that, for the reason why we're here, the court does have to look at something other than the offense charge. I know it's a good one.
I understand that, but this, you would have to admit, is a unique fact circumstance.
Absolutely.
This is not a whodunit. The actions are very evident. What the end result of that is, that's the purpose of the case as we're proceeding.
Yeah.
So, all right, I understand your argument. Still,
Your Honor, if I may respond, she went through a lot of the statutes. Unfortunately, she forgot the Kentucky Constitution, section 16 says that all people are entitled to bail unless there's a capital offense. And the word she was looking for is when proof is evident, the presumption is great. There's just recently in 2024, a Kentucky Supreme Court case on this issue. It was out of Breckenridge County, if I'm not mistaken. The site on that is 2024 WL 298-2769. That is a case in which, much like we are sitting here today, the defendant was charged with capital offenses. The Commonwealth had made a statement on the record they were not seeking death in that case. That statement made at that point in time, the judge set a bond over the Commonwealth's objection. The Commonwealth then filed an appeal on that issue. Supreme Court come back and did the exact analysis they're asking you to do. And basically, what he did in the community, what he did is irrelevant. The only thing that's relevant is, in fact, the charges themselves. And the Supreme Court said, if you are charged with a capital offense, you are not entitled to bail. And they overturned a circuit judge and sent it back to no bail. So there's a case already up there the Supreme Court issued last year. I gave the citation for it. And the case number on that is, or the case name on that one, I don't think I gave you that, is Commonwealth versus Rodney Jones. And Judge, there's enough in the record already. You can take judicial notice. That's why the Commonwealth introduced the video here at the preliminary hearing. It's very clear what happens in the preliminary hearing. They were counseled record at the time, so there's not an issue. They did cross-examination of that. The record is very clear. The video is very clear. And Mr. Stein, in fact, took the life of Mr. Mullins. So that's all required. Even under the case law, the Constitution, he is not entitled to bail.
Your Honor, if I could briefly respond. I do have a piece of case law I can cite here, Judge. It's Burton v. Commonwealth. It is an older case. It's 212 Southwest 2nd, 2010, Judge. Does show that the court can take into consideration the mental state of the defendant when setting bond in a capital case. So if this case was basically where evidence introduced in a hearing on motion for bail showed defendant to not be guilty of murder, but only voluntary manslaughter, in the event that the jury did not find self-defense, the proof of guilt was not evident, nor the presumption, right? So I think the court can take that mens rea into consideration and that mental health evidence into consideration, which is again why we want to do the interview staff.
all right, thank you. In response,
Judge, I believe the case I cited speaks right to the issue.
All right. All right, as with the other issue, like I said, here's what I'm gonna do. Mr. Steele, you said that you all would file a written response on the KCPC evaluation within 10 days. So,
On a motion to unseal?
yeah,
Yes, Your Honor.
why don't we do this? If anybody wishes to submit case law or supplement anything in regards to the pleadings on all three of these matters, if both sides will do it simultaneously within 10 days.
Within 10 days, Your
Within
Honor?
10 days.
Yes, Your Honor.
Yes, sir.
And then that'll give us time. I'm gonna try and expedite rulings on this, and then we can start looking realistically more at setting a next hearing. And I think once we get these initial matters addressed, we can then start realistically looking at potential trial date
Yes, Your
for all parties. So
One thing, Judge,
Sure.
can we do 10 days from Monday, since today's kind of
Yeah,
shot next
10
week?
days.
Yeah.
Okay, so everybody is asking, everybody is a little bit confused, and they think that that is the judge's wife and her kids sitting behind the prosecutor. No, the older lady is the victim's advocate, and the one in the white blouse, button-up blouse, is the judge's wife. It's not his kid. That's his wife. And the blonde that's sitting there holding her hand is prosecutor Matt Butler's ex-wife. So that's who those are. That's not his wife and her kid and their kids. That's his wife. She was awful young. Both of them were whenever they got married. So Butler married a very, very young girl, and so did the judge.
your motions.
I'd rather under promise and over deliver, Your Honor.
All right, why don't we do this? And both sides will have till Tuesday, September 2nd.
Yes, Your Honor.
That should give everybody plenty of time.
Thank you, sir.
All right, and then after I get those pleadings, I will notify the parties, and we'll get a more realistic timeline on when we'll set the next hearing.
Yes,
All
sure.
right, other than these three matters, I know we have one matter that we'll have to address ex parte that we'll talk about in just a minute. And for purposes of record, the Commonwealth, you've been given notice that they filed for an ex parte hearing in regards to funding.
Yes, Your Honor.
All right, and you're aware that the court will address that at the conclusion.
Absolutely, Judge. Just to make the parties aware of talk in chambers, we are looking for an expert on this issue, and
Sure.
and there's plenty channels we have to go through depending on what those come back as for an expert also. So we made counsel aware of that also.
All right, thank you, Mr. Steele. Anything else we need to address today before we adjourn before the ex parte hearing?
No,
You're
All right, ladies and gentlemen,
Yes, so the lady in white right there, that's Judge Mullins's wife. She was very young when they got married. Somebody close told me that she was 22, I think, or 23. I also heard she was underage whenever they first started. So I don't know what the truth is, but it's somewhere. The truth is usually somewhere in the middle. So it could be anywhere between underage and 23 was when they got married. And they've got kids that are my kids' age. So, or close to it. The blonde that's sitting there with her, holding her, that's her sister. That is Butler's ex-wife. Which he's on marriage number 3 now. And he just announced it. He's on marriage number 3. And he's got a whole bunch of kids. So, the apple don't fall far from the tree, y'all. I mean, when you've got every one of these men that are like old enough to be their dads or their grandpas. I mean, one's even old enough to be her great grandpa, Come on, man.
when pursuant to the rules, what we're about ready to have an ex parte hearing in regards to one matter. I'm going to be in recess for about 5 minutes to give time for the courtroom to be clear. Obviously, defense counsel and the defendant will be able to remain for that part of the hearing.
Yes, sir. Thank you, Your Honor. We'd like to.
What's that?
Yes, Your Honor. We wanted to talk to him for just a minute.
Yeah, absolutely.
Take care.
All rise.
Thank you.
Please start clearing the courtroom, please.
All right. And the people that are sitting in the back, in the row right behind them, that's all their family. That's the judge's wife's family all back there. And that's Mickey's wife going right there. Somebody sent me some pictures this morning of his son. That's Mickey's son standing back there. See there? We got family. That's the prosecutors right there. Butler. But. Interesting. Very, very interesting to see who all is in the courtroom, isn't it? Yeah, Mickey's wife was there. His daughter's been there. That's his wife. And that might be his daughter right there. I didn't see her in there, though. I didn't see his daughter whenever, unless she's changed her hair color. I didn't see her dark hair. She could have changed her hair color, and I just didn't recognize her face. See, there's Mickey's wife right there in dark hair. Yep, her son. And that's his son, his son's wife right there. Yeah. His daughter's not there today. I didn't think I saw her. I guess I don't know. They took her that way, and there's a holding cell. So on the side where the judge's wife just walked, there is like a little area where the inmates sit. So when they bring the inmates up from the jail downstairs, there's like a holding cell, and then they can bring them out of the holding cell, and it just seats like that, and they can sit them over there in that little seated section. So I don't know. They've either taken her over there, probably just to talk to her and prepare her for whatever next steps. Now remember, guys, we have memberships. If anybody wants to gift any memberships, we have hillbillies that really, really appreciate that. They can't, some of them can't do it. So those who always gift memberships, it's for a good cause. Makes them feel very special. We thank you for all of your generosity to each other. Let's see. And then you've got a ton of camera people there. Now that's our new sheriff right there in the bulletproof vest standing there. That's Jones, Billy Jones. He's I talked to him. He he actually served my divorce papers to me. And he's very soft spoken. He's real calm and settled. You're on mute, Mommy, if you've been talking any. I didn't know if you had. Did you know, Mom? Zelmy, can you hear me? Huh. Hey, Zelma, can you hear me?
Now I'm not on mute.
There you go. You scared me to
Yeah, I like that Billy Jones.
Let me turn my thing back down. Something blew us out of our chairs.
I like that feller.
You do, yeah.
He stopped this
Okay.
morning and let me cross the street in front of him.
Oh, well, that's nice. Yeah, he seemed like he's one of those kinds of people that he would be real, polite, and
He'd stop
stuff.
and help you if you had a flat tire.
Yes, everybody. So Sweet Tater is my little mommy. She is my co-host on Hillbilly Crime. Mommy taught at our local community college. She taught math, and all different types of mathematics. And she's taught there probably 40 years or more. So she is a staple in this community as well. If you went to our local community college at any point in time in the last 4 decades and you took math, you probably had her. She is a wonderful math teacher, and she still does part-time. Yeah, she still works part-time. That looked like Borum's. I think that's that cop that pushed all that on me. He's a sheriff's deputy now. He used to be a deputy at Neon Police Department. He was the one who went down and allegedly sat at the fire department for a month trying to solicit a statement from an EMT or a fireman, whoever would write it for him, that he could take to the grand jury and use along with his own statement. So then it wouldn't just be him going down there testifying. He'd be able to take somebody else's statement down there with him. So it wouldn't look like he was doing it. You can't do that. You can't do that. And that's him right there. That big old beard. I don't like him at all. I cannot even get in his presence without my whole body just going into DTs. And you imagine how many people they do that to. Well, there's the end of it.
Well, I'm going to go take a nap.
What? I didn't know where that was coming from. I was like, oh, shit. Oh, are you going?
I'm going to take a nap.
Oh, okay. Well, have a good nap. Bye. Love you.
Love you, bye.
All right. Let's kick Sweet Tater off of there. All right. Well, what do y'all think? What do y'all think? For a town called Neon, I have questioned how bright they really are. Won't even touch it. I won't even touch it. At one point in time, the police chief in Neon, we even had a police chief who helped a bank robbery, who helped in a bank robbery, who was addicted to snow-cane. We had a police chief who addicted to snow-cane and who helped commit a bank robbery. Yeah, we did. And it's like, no big deal. Didn't you have a didn't your police chief do stuff like that too? All about how dare anybody ever even think or say what somebody's done. We've had such a hard time here in this area with corruption. I mean, it's generational. It's absolutely been generational. Well, listen, guys, I'm going to wait for tonight for our show to go into any of our other stuff that I've got planned. Come back tonight, 8 o'clock, and we're going to have a really, really good show. Hopefully by then, we will have seen something come of this. But if not, I've still got some new stuff. We're going to look at some new stuff. We're going to look at some new claims, new accusations. I don't know if it's accusations, but somebody's own personal experience. Just doesn't never stop. All right, y'all. We will see you back here. Hillbilly Crime at 8 o'clock, okay? Peace out, Girl Scout.
You can't hide from hillbilly crime.
You can't hide from hillbilly crime.
You can't hide from hillbilly crime.
You may not know that there's a crew in town. The head hillbillies are making their rounds. Small town whispers loud and clear. The sheriff shot the judge in his chambers chair.
Sheriff got a secret he won't keep. Judge shot dead in his disbelief. A lot of people have some stories to tell. Dark pass away, get the sound of a shotgun shell.
All the secrets spill on down. Voices loud in this old town. From the courthouse to the ground. Rumors fly and they can't be bound.
Neighbors hide behind their blinds. Whisper tales of troubled minds. Skeletons covering the mountainside. A treacherous reality in the pines.
Winter reveals the hidden lies. Moonlight couldn't mask the cries. Shadows caught in sunlit skies.